In a 57-page powerful order, the D.C. Circuit Court of Appeals panel unanimously found that Donald Trump does not have absolute immunity. This was a per curiam opinion, meaning all three judges on the panel, Judge Henderson, Judge Childs, and Judge Pan, all affirmed the district court's ruling denying Donald Trump's motion to dismiss on absolute immunity grounds. Let's take a look at the judgment. Then let's go through this 57-page order. Here's the judgment right here. Again, you'll see it says the three judges' names, Henderson, Childs, and Pan. Henderson appointed by Republican administrations, Childs and Pan by Democratic administrations. Here's the judgment. This cause came to be heard on the record on appeal from the United States District Court for the District of Columbia and was argued by counsel. On consideration thereof, it is ordered and adjudged that the order of the district court appealed from in this cause be affirmed in accordance with the opinion of the court filed herein this date. The clerk is directed to withhold issuance of the mandate through February 12th, 2024, if within that period, appellant, meaning Donald Trump, notifies the clerk in writing that he has filed an application with the Supreme Court for a stay of the mandate pending the filing of the petition for a writ of certiorari. The clerk is directed to withhold the issuance of the mandate pending the Supreme Court's final disposition of the application. And folks, that language right there is very important and I think will need to be talked about more throughout the day. In other words, the D.C. Circuit Court of Appeals here is telling Donald Trump that you have a deadline by next Monday, by February 12th, to go to the Supreme Court. So no delays, Donald Trump. And if we don't hear back that you sought review by the United States Supreme Court by February 12th, this gets sent right back to the District Court Federal Judge Tanya Chutkan, and then the case can proceed expeditiously again before Judge Tanya Chutkan. So this is a way the D.C. Circuit Court of Appeals panel is not allowing Donald Trump to delay. And for, I think, everybody who was getting a bit frustrated over the fact that this D.C. Circuit Court of Appeals was taking a very long time to rule, this very short deadline for Donald Trump to now have to go to the Supreme Court if he's going to appeal the ruling by this three-judge panel, I think actually moves things along quite expeditiously. Now let's take a look at the ruling itself. Let's start off just with the introduction here, and then I'm going to go to the key portions of this ruling. So here's just how the ruling starts. Again, per curiam, it says, Donald Trump was elected the 45th president of the United States on November 8th, 2016. He was sworn into office at noon, January 20th, 2017, and served until his term expired at noon on January 20th, 2021. At that moment, President Trump became former President Trump, and his successor, Joseph R. Biden, became President Biden and began his own four-year term. United States Constitution, Article 2, Section 1. Although this sequence is set by the Constitution, it did not proceed peacefully. Indeed, from Election Day 2020 forward, the government alleges that President Trump denied that he has lost his bid for a second term and challenged the election results through litigation, pressure on state and federal officers, the organization of an alternate slate of electors, and other means. His alleged interference in the constitutionally prescribed sequence culminated with a Washington, D.C. rally being held on January 6, 2021, the day set by the Electoral Count Act. Goes on to say, the rally headlined by President Trump resulted in a march of thousands to the Capitol and the violent breach of the Capitol building. The breach delayed the congressional proceedings for several hours, and it was not until the early morning of January 7th that the 2020 presidential elections were certified, naming Joseph R. Biden as the soon-to-be 46th president. Since then, hundreds of people who breached the Capitol on January 6, 2021 have been prosecuted and imprisoned. And on August 1, 2023, in Washington, D.C., former President Trump was charged in a 4-count indictment as a result of his actions challenging the election results and interfering with the sequence set forth in the Constitution for the transfer of power from one president to the next. Former President Trump moved to dismiss the indictment, and the district court denied his motion. Today, we affirm the denial. For the purpose of the criminal case, former President Trump has become Citizen Trump, with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. Again, referring to Donald Trump, you are Citizen Trump. You are no longer President Trump. You are a former president. You have the same defenses as any other criminal defendant. The order then goes on for a number of pages that gives the background of events here leading to the indictment being brought by special counsel Jack Smith by the Washington, D.C. grand jury. There is a number of pages that discuss the jurisdictional issues. Remember how we discussed this Midland asphalt case? The D.C. Circuit Court of Appeals here found that despite the language by the United States Supreme Court in this 1989 case called Midland asphalt, which says there needs to be explicit statutory text or constitutional text to support what's called an interlocutory appeal through a collateral order, meaning could this denial of Donald Trump's motion to dismiss on the grounds of absolute presidential immunity even be appealed at the stage, or do you have to wait for a final judgment? Here, the D.C. Circuit Court of Appeals said that based on D.C. Circuit precedent, they think they have jurisdiction to hear this case. You know, honestly, when I read that portion, it still seemed like maybe the D.C. Circuit Court of Appeals had some questions whether they really had jurisdiction or not, but they really wanted to make this order because, you know, the language in this order is very, very powerful stuff. Like over here, they talk about how, this is from the order, we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their votes counted. I mean, think about that language right there from the D.C. Circuit Court of Appeals panel. Here, they go on to say the following, and this is on page 20. Former President Trump's claimed immunity would have us extend the framework of presidential civil immunity to criminal cases and decide for the first time that a former president is categorically immune from federal criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility. He advances 3 grounds for establishing this expansive immunity for former presidents. Article 3 courts lack the power to review the president's official acts under the separation of power doctrines. 2, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on the executive branch functions. And 3, impeachment judgment clause does not permit the criminal prosecution of a former president in the absence of the Congress impeaching and convicting him. Our analysis is guided by the this is now what the D.C. Circuit Court of Appeal panel says. Our analysis is guided by the Constitution, federal statutes, and history, as well as concerns for public policy. Relying on these sources, we reject all 3 potential bases for immunity, both as a categorical defense to federal criminal prosecution of former presidents and as applied to this case in particular. So what we see is Why was the DC Circuit Court of Appeals taking this additional time? All three judges were in agreement with this final ruling. So what was the delay? Just think they were dotting their I's and crossing their T's here and making sure that this was a powerful appeal-proof order right here, which they delivered. Going to the functional policy considerations, they describe the following. This is from the order on page 31. We note at the outset that our analysis is specific to the case before us, in which a former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. We consider the policy concerns at issue in this case in two respects. First, we assess possible intrusions on the authority and functions of the executive branch and the countervailing interests to be served, as those concerns only apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. We conclude that the interest in the criminal accountability held by both the public and the executive branch outweighs the potential risks of chilling presidential action and permitting vexatious litigation. Second, we examine the additional interest raised by the nature of the charges in this indictment. The executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, and the voters' interest in democratically electing their president. We find these interests compel the conclusion that former President Trump is not immune from prosecution under the indictment. So they go through all of that. Let's go through page 38. It talks about how the president, of course, has a duty to take, under the Take Care Clause, to faithfully enforce the laws. This duty encompasses following the legal procedures for determining election results and ensuring that executive power vests in new presidents at the constitutionally appointed time. To the extent former President Trump maintains that the post-2020 election litigation that his campaign and supporters unsuccessfully pursued implemented his take care duty, he is in error. Former President Trump's alleged conduct conflicts with his constitutional mandate to enforce the laws governing the process of electing the new president, taking care that the laws be faithfully executed, the peaceful transition of power, not trying to overturn the peaceful transition of power. The court goes on to say the public has a strong interest in the foundational principle of our government that the will of the people, as expressed in the Electoral College vote, determines who will serve as president, as the United States president. And then it goes on to say, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He allegedly injected himself into a process in which the president has no roles, the counting and certifying of Electoral College votes, thereby undermining constitutionally established procedures and the will of Congress. To immunize former President Trump's actions would further aggrandize the president's office, already so potent and so relatively immune from judicial review, at the expense of Congress. So going through all of Donald Trump's arguments one by one and knocking them down. And here's the conclusion. We have balanced former President Trump's asserted interests in executive immunity against the vital public interests that favor allowing the prosecution to proceed. We conclude that concerns of public policy, especially as illuminated by our history and structure of our government, compel the rejection of his claim of immunity in this case. We have also considered his contention that he is entitled to categorical immunity from criminal liability for any assertedly official action that he took as president, a contention that is unsupported by precedent, history, or the text and structure of the Constitution. Finally, we are persuaded by We are unpersuaded by his argument that this prosecution is barred by double jeopardy principles. Accordingly, the order of the district court is affirmed. So now, folks, Donald Trump has until Monday, February 12th to appeal to the United States Supreme Court, or the district court proceedings resume. This panel clearly holding Donald Trump's feet to the fire. 57 pages, each page very powerful, and saying that we are a nation of laws. And the allegations against Donald Trump in the indictment, if true, demonstrate the complete destruction of our Constitution, for which no one is above the law, even presidents and former presidents. I'm Ben Meiselas. This is the MeidasTouch Network. A big breaking news update there, folks. If you want to support journalism like this, go to patreon.com/MeidasTouch and sign up for our newsletter, MeidasTouch.com/newsletter.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.